At ALLFIE, we've been speaking with solicitors to answer some of the questions around systemic barriers to inclusive education for disabled children and young people. In this video, Richard Nettleton from SEN Legal will be answering our questions around managed moves and transfers. What do they mean, and what are our rights?
So my name is Richard Nettleton. I'm Solicitor and Director at SEN Legal. Today I'm speaking to you about managed moves, managed transfers. The information provided in this Q&A is for general informational purposes only and does not constitute legal advice. If you require legal assistance or advice, I strongly recommend consulting a qualified legal professional who can provide guidance based on your specific situation.
What is a managed move, and how is it different from a managed transfer?
So in terms of answering the question about a managed move, the context is really useful in explaining that. So the situation for where you would be involved in a managed move in the first instance, the managed move is used when a student is at risk of permanent exclusion, all the strategies that could be used have been exhausted, or there's a breakdown in the relationship between the pupil, the family, and the school. Therefore, a managed move is a formal agreement between a student, current school, and another school to transfer that student, normally following a trial period, which is typically around 12 weeks. Normally, it's referenced as a fresh start and often used as an alternative to exclusion. A managed transfer is different from a managed move in terms of it doesn't normally involve a trial period inside it, and it's a direct relocation of the student without the ability to reverse the trial and go back to the original school.
What is the legal framework for a managed move?
There is no legal framework in terms of acts of parliament similar to exclusions and other areas there. Managed moves are referenced in a guidance document, suspension and permanent exclusion, which is updated usually every year or every couple of years, and is referenced inside that document there. So while it doesn't have a legal framework to it, it has a couple of bullet points about what should be considered in respect of a managed move, and that provides the basis for anyone looking into this particular area.
If a school or college initiates an agreement, what should parents look out for to ensure that the best interest of the young person is fully protected?
So that's a really good question. So it's making sure that one, it's a managed move and not a transfer, unless that is what you want in the situation. Um, Classic things to look out for are how long is the trial period going to be? I reference it's normally 12 weeks, but it can be as long as someone wants it to be, if all parties are in agreement. And then what measures are going to be used to determine success? Because at some point, the end of that trial period is going to end, and what you want to work out is this the school that we want to stay at going forward? Another thing to potentially look out for, or potentially sort of think about, is a school visit to the new school that's being proposed, so that you can just get a lay of the land, a feeling of the school. Most schools are normally okay with that visit and organising that, but just so that you can lay eyes on the place and get a general feeling for it.
Can a parent or young person ask to have a managed move to another school? Or is it just legally between the head teachers of both schools?
A parent or young person can ask, however, the schools do not need to agree. Um, Ultimately, managed move and managed transfer are a voluntary process that are designed to provide a fresh start, but all parties need to be in agreement that that is what is going to happen for it to happen.
If a school or college proposes a managed move to another school, can the parent or young person say no?
Yes, you can absolutely say no to a managed move if it's or a managed transfer if it's proposed. It is designed to be a voluntary agreement between all willing parties as opposed to some forced measure on individuals. So yes, you can refuse a managed move or a managed transfer if you do not agree with it.
When can a managed move be used for permanent exclusion?
So a managed move cannot be used for permanent exclusion. It cannot and should never be threatened as an outcome. It is supposed to be an alternative to a permanent exclusion going forward when all options have been diminished and cannot occur going forward. Um, if this threat is made, though, i.e., accept the managed move, otherwise will permanently exclude you, then that's potentially a complaint to the school, the governing body, or the local authority, depending on what type of type of school it is. However, it should not be used. The permanent exclusion shouldn't be almost the carrot so to speak, in forcing you to engage with the managed move. Managed move is just an alternative option as opposed to accept this or else.
What happens if the managed move doesn't work out?
So if a managed move doesn't work out, you'll return back to the original school and continue at that school. Um, that is simplistically the end of the process. However, if further issues occur, then you're likely to want to seek legal advice in respect of those issues.
Are other students in the new school informed of the managed move?
Normally, other students wouldn't be informed of that information. They'll only find out that information if the parent or the young person slash child shares it with other students, but it's not normal practice for that information to be shared.
What happens regarding attendance record during this period of time?
In a managed move, attendance will be recorded by the new school. However, you'll remain on both schools' roll slash register during the trial period. Once the trial period is finished, you'll either stay on one school's roll or return back to the original one. But during the trial period, you'll be dual located on both registers.